Well, hello, everybody, and welcome to today's Venable Nonprofit Organizations Practice Group monthly webinar entitled Helping Nonprofits Navigate the Changing Landscape for Inclusive Programs. I'm George Constantine. I co-chair Venable's Nonprofit Organizations Practice Group along with Janice Ryan. And I know today's program is one that's very topical for many of our clients. It's some issues that we've been addressing regularly since the new administration, and I think what be fair to characterize as a bit of a struggle among nonprofit organization leaders and advisors as to how to balance some of these new and still uncertain compliance risks against, sticking with the mission of the organization that you work for or with. And so we've been helping organizations try to navigate that for a little while now, at least 5 months or so. So we're hoping to share some of that today. The way we're going to do today's program is we're dividing it up between sort of the labor and employment side and some of the issues having to do with continuing to be an inclusive workplace while managing against risks that are sort of increasing on the sort of from the administration and from private plaintiffs. And then talk more about the programmatic side. And you as nonprofit organizations offer many programs and activities and benefits that may sort of chafe against some of these new rules or guidance or executive orders and other things that are coming out. So thought it would be a natural split. And I'm really excited to have my colleague and partner, Robin Burroughs, along with us for today's program. Robin is a partner in our labor and employment practice and has done a lot of work over the years assisting employers on litigation issues, on counseling, labor relations negotiations, and has been very much sort of in the fray when it comes to discussing these new policy positions that are being propounded related to employment and inclusivity, and will be a great representative of that side of the discussion today. Before I turn it over to Robin, just briefly give you sort of maybe a preamble or a disclaimer. This is a very uncertain area, and I know that the term uncertain is one that's come up a lot lately, but I think it's important to mention that here, and that a lot of what we're going to talk about are interpretations we're having to make based on some sort of in-process trends in the courts, what's happening from the executive orders that we're hearing, and some pronouncements from EEOC, Department of Justice, others, none of which is very 100% definitive yet. And so a lot of what we're talking about is going to be helping you identify risks, and helping you make good decisions based on what those risks might be. We're the lawyers, right? So we're advising on the legal side of the risk, but there are other risks that will come up when you consider what to do related to the current environment. Reputational, many of you have members, many of you have constituents and other groups. So I understand that there's going to be a balancing decision that you all need to make. We're just hoping to give you as much of the contours as we can on the legal side to help you make that decision in an as informed way as possible. So with that, I will turn it over to Robin. I'll sort of skip past our bios and get to your first slide.
Thanks, George. Yeah, thank you. And thanks to all of you for joining us today. And what, as George was pointing out, is a very changing landscape for a lot of you and for us as well. Today, we'll cover a number of things. I'll start by talking about the employment law, both the landscape and the recommendations and trends that we're seeing for employers. And then George will jump over to talk about some of the nonprofit programmatic and activity implications that come from these executive orders and from the changing landscape. Go ahead, next slide.
Yeah, and to the extent we do have time, we'll try to do the questions at the end. So I know you can flow them in through the Q&A function, but we'll probably not tackle those until we have time at the end.
Thank you. Yeah, so a good bit going on here in the employment landscape. Before we jump into exactly what the executive orders say, I want to talk about what DEI actually is. DEI doesn't have a definition. It isn't defined in any of the executive orders that we're going to be talking about today. but it is a term that I'm sure you've heard and may even have used with your organization. Really, when we're talking about DEI, we're talking about diversity, equity, and inclusion initiatives. Sometimes DEIA, which includes accessibility. But we're talking about initiatives that are really a collective set of principles and practices aimed at fostering fair treatment, representation, and participation in the workforce and in your programs, especially with historically marginalized or underrepresented groups. That said, DEI doesn't have a singular or universally accepted definition. It may mean certain recruitment or hiring practices. It could be equitable professional development opportunities. It might mean ensuring representation in leadership or just focusing on workplace culture. It could be all of those things or additional things at your organization. It's really a set of practices and principles that has developed over some time to the point where now we just use DEI as a shorthand for these sorts of principles and initiatives. There's nothing wrong with diversity or equity or inclusion. We'll talk about that a little more as we move on. None of those words are illegal or have become illegal as a result of any of these executive orders, as long as your programs don't violate applicable anti-discrimination laws. That has always been true. And as we'll talk about, based on the guidance we have right now, that remains true. The Trump administration has issued executive orders which really impact some particular DEI practices. Executive orders are primarily to provide information to executive agencies and to set administrative policies. They don't create new laws, they don't change existing laws, but as you may have seen and as you may see in the future, they can significantly influence how those laws are enforced and how programs are administered. And that's really the impact we'll be talking about with these executive orders, is how do these executive orders change the way that employment anti-discrimination laws have been implemented and administered under this new administration. Go ahead to the next slide. So we'll talk about three kind of key executive orders. To the extent you don't know about them already, we'll just introduce the main employment-related aspects of these. The first one, ending radical and wasteful government DEI programs and preferencing. That executive order was really targeted at eliminating DEI programs in the federal government itself. So while the executive order did say that it wanted to eliminate DEI offices and eliminate DEI officers, that likely does not apply to your organization as a nonprofit. It applies to agencies and policies within the federal government itself. That said, it does set a pretty firm signal that the administration did not like the term DEI or DEIA, or the kind of offices and programs that those agencies were administering under the umbrella of that term. The next executive order, defending women from gender ideology extremism, changed defined the sex as an immutable biological characteristic and tried to remove concepts of gender identity. I say tried to remove because, again, we're talking about executive orders, which primarily give direction to federal agencies. They don't change existing case law, which has said that gender identity remains a protected characteristic in employment. But as far as the administrative agencies that administer these non-discrimination laws are concerned, the executive order has shifted away from the spectrum of gender identity, something that was previously more recognized, and really shifted into the characteristic of being male or female. This has come most keenly into the public consciousness with regard to single-sex spaces like locker rooms, changing facilities, and things like that, bathroom access, where your organization may be having questions from employees about, how do we let employees use the bathroom now? a question that doesn't have a full answer at this point, as George was mentioning, but definitely something where we're seeing a shift based on the administration's executive order. Go ahead to the next slide. And then finally, the one that maybe most clearly touches on a lot of the programmatic aspects and many of the internal DEI programs you may have had in the employment context was ending illegal discrimination and restoring merit-based opportunity. This executive order required all agencies and departments to end discriminatory and illegal preferences, mandates, policies, programs, activities, regulations, anything that they considered to be discriminatory and illegal. It rescinded a number of executive orders that applied in the employment context, including the executive order that required federal contractors to develop and implement affirmative action programs. And it required agency heads to encourage the private sector to end illegal DEI preferences through developing a strategic enforcement plan. The strategic enforcement plan date was May 21st. We haven't gotten a lot of insight into exactly what kind of strategic enforcement the administration is looking at now that that date has kind of come and gone. We've seen some groups being targeted for DEI-related programming, including law firms and universities, but there hasn't been a filed list of targeted employers, even though the executive order asked agencies to sort of come up with a list of employers who were taking part in potentially illegal practices. This last executive order is perhaps the broadest that targeted employment practices across a wide variety of definitions that the administration appears to have felt were a bridge too far. Go ahead to the next one, George. Thanks. As you may know or can imagine, a lot of these executive orders were challenged in court. There have been a number of challenges, and we won't go through all of those, but I've highlighted just one here, the National Association of Diversity Officers in Higher Education, which tried to enjoin or stop enforcement of that last executive order we just talked about. They had some success in the lower court stage. A Maryland district court temporarily blocked the certain provisions of that executive order, but it was ultimately overturned in the Fourth Circuit. So the executive order continues on right now. The court's opinion in this case was very fractured. And I just am drawing our attention to one quote here from Judge Pamela Harris, who wrote a concurring opinion in that case. She said the executive orders do not purport to establish the illegality of all efforts to advance diversity, equity, or inclusion, and they should not be so understood. Instead, the executive order applies only to conduct that violates existing federal anti-discrimination law. In other words, the court is saying there is nothing new here in this executive order. There's nothing to stop enforcement of, because all the executive order was saying was, if it was illegal, we're going to go after it. And that is really the best guidance that we have to date about what to do. Not necessarily this concurring opinion, but this concept that the executive orders are targeting practices that were previously illegal and continue to be illegal under existing anti-discrimination law. So let's go to the next slide and we'll talk about what those are. You're probably familiar with most of these employment-based federal anti-discrimination laws. Title VII is the first one, prohibits discrimination in employment on the basis of race, color, religion, sex, and national origin. Different laws protect characteristics like disability, age over 40, genetic information, and military service. These are the big kind of protected categories that you've probably seen and are aware of. None of this has changed with the executive orders. These federal anti-discrimination laws remain. And Title VI of the Civil Rights Act applies to employment only in organizations that receive federal financial assistance. It will also apply to some of your programmatic aspects, but it prohibits race, color, and national origin discrimination if your organization receives federal financial assistance. So it's a subset of those protected categories. It also applies in the employment context, but only if you take federal funds. Title IX of the Education Amendments Act of 1972 applies to gender. You might be familiar with Title IX in the context of collegiate sports, but it prohibits discrimination on the basis of sex in education programming and activities that receive federal financial assistance. So even a little more limited than Title VI, not just organizations that receive federal financial assistance, but ones that are educational programs and activities. It also applies in employment if your program happens to be subject to Title IX. And then Section 1981 of the Civil Rights Act prohibits race discrimination in contracting. We haven't seen a ton of action on the litigation scene under Section 1981 in the employment context, so it might not be one that you're really familiar with, but it does apply in employment relationships. George will talk a lot more about it as it relates to those programmatic aspects of what your organization may do. But the employment relationship is a contractual relationship at its core. And so Section 1981 can apply to that as well. It only prohibits race discrimination. It's limited. It doesn't prohibit religion or disability or any of those other protected categories. It does apply to private organizations, including nonprofits, no matter how many employees you have. So while Title VII applies usually when you have 15 or more employees, Section 1981 will apply even if you are very small and only have one or two. Unlike Title VII, where you have to take a case to the EEOC before you can bring it in court, Section 1981 has no administrative exhaustion requirement. It is a little more limited in what types of claims you can bring. Plaintiffs have to prove intentional discrimination, disparate impact, or the idea that a neutral policy has treated one group differently than another is not sufficient to show discrimination under Section 1981. We've been seeing a lot more cases recently coming under Section 1981, sometimes along with Title VII cases, sometimes separately, because there are some groups that Section 1981 will apply to, like independent contractors, that Title VII does not cover. So we are seeing more and more these two different types of anti-discrimination law coming together in a single lawsuit or under a single action. If you hadn't been thinking about Section 1981 before these executive orders, you should really be thinking about it more now. It's something that plaintiffs have been relying on more and more, and I think we're going to see more activity under that in the employment sense. Go to the next slide. So none of those anti-discrimination laws have changed given the executive orders. The place where we're seeing change is how they're being enforced. So the first agency on this list enforces Title VII and some of those other anti-discrimination laws about protecting disability and age. The EEOC investigates discrimination complaints, issues right to sue letters, and can even litigate on behalf of employees. We're seeing changes in the enforcement of the anti-discrimination laws at the EEOC level. This doesn't change whether or not a plaintiff can bring a particular type of case, but we have heard of the EEOC taking fewer and fewer cases involving things like gender identity discrimination. This isn't uncommon. When the presidential administration shifts, their enforcement priorities often shift, and the EEOC, as sort of an agency of the federal government, shifts along with that. So each presidential administration brings a different set of priorities to bear. And we're seeing that happen with the EEOC. As we'll talk about soon, the EEOC has also issued some additional guidance on DEI-related programming that suggests that they are looking more deeply into it than the previous administration's EEOC was. The Department of Justice is another federal agency which is driven by these executive orders. It enforces federal statutes prohibiting discrimination in employment only in a limited number of circumstances. Mostly those cases go to the EEOC. The Department of Justice takes a very small subset of them, usually related to governmental employers. Department of Justice, though, enforces those same laws like Title VII in other areas like education, housing, public accommodations. So as you're going to see in a minute, the Department of Justice and the EEOC have issued joint guidance and have been somewhat in alignment about how they're looking at inclusive programming under these anti-discrimination statutes. The other place where we've seen these executive orders having an impact is with federal grant-making agencies. If your organization takes federal money, either grants or loans or any other type of federal funding, those agencies are digging deeper into those grants, loans, and other programming in order to see if you are violating anti-discrimination laws and taking federal funds at the same time. Those include employment, anti-discrimination laws, and those also go to some of the programmatic aspects that nonprofits do. And finally, kind of the last bastion, if you've gone through all these agencies, is a private lawsuit from individuals. Private lawsuits still move forward under traditional principles. So if an employee brings their case to the EEOC and the EEOC says this is not an enforcement priority for us, they will issue a 90-day right to sue letter, and then the employee has 90 days to bring their case in federal court. Since nothing has changed in the anti-discrimination laws, employees can still bring private lawsuits based on all of those protected categories. We are seeing a rise in interest in what were previously called reverse discrimination cases, or cases brought under the idea that the majority individual in a majority characteristic. So, for instance, a white individual is being discriminated against in favor of a Black individual. And that is really at the core of a lot of these DEI-related employment lawsuits. Those can still proceed. The opposite, a minority individual who feels they've been discriminated against, those can still proceed as well, even if the EEOC hasn't taken a great interest in some of the protected categories, such as gender identity. All they'll do is issue a right to sue letter, and the individual can still bring a private lawsuit. That hasn't changed either. Go ahead to the next slide. So as I mentioned, the EEOC and the Department of Justice have issued new technical guidance specifically related to DEI. Nothing in this guidance was new under the law because the EEOC cannot change the law by itself. But it is definitely a twist on existing law with a focus on DEI that shows that the Department of Justice and the EEOC are both looking at these programs through a new lens and much more closely. The guidance signals the EEOC will be pursuing these programs much more aggressively and taking a much more expansive view about the types of things that it would consider adverse. So it's still going to look at any programming that might limit, segregate, or classify individuals by race, gender, or any of those other protected categories that they enforce under Title VII. But they're looking at that through a DEI lens. So if you are limiting, segregating, or classifying your employees for the purpose of an affinity group, that is something the EEOC would consider problematic. Harassment or retaliation, like I said, based on those protected characteristics, still protected and still prohibited. But the EEOC and DOJ are looking at this through the lens of a DEI program. So does your training on DEI constitute harassment against a majority group individual? It's nothing new in the way of the law, but it is certainly a twist and a different focus than the previous iteration of the EEOC was looking at for these programs. Under the Biden administration, the EEOC was very pro DEI programming, and that has flipped. Go ahead to the next slide. So in the EEOC and DOJ's sort of frequently asked questions list, they really highlight a couple of places where you as employers could be looking to make sure that you have the proper programs in place. So when looking for DEI-based discrimination, the EEOC is looking at training opportunities, mentorship, sponsorship, workplace networking, internships, fellowships, interview selection committees. Some of these areas aren't new. You should not be, selecting individuals for employment based on their race or gender. But this is definitely a more aggressive, more expansive view than what the EEOC was looking at before. Internship programs have been on the EEOC's radar and subject to some litigation for a while. But things like mentorship programs and interview panel selections are somewhat of a newer focus for the EEOC. The affinity groups is also something that the EEOC is looking at very closely. If you have an affinity group program as an employer and you were segregating or limiting employees who could join or participate in your affinity group programs, that is something that the EEOC would be very concerned about. So for example, if you have a Black employees affinity group, and limit its programming or its meetings or its leadership to be only people who consider themselves to be Black employees, that is something that the EEOC would consider discriminatory. The EEOC's view is that there is really no such thing as reverse discrimination. There is only discrimination based on race. So if you're limiting your affinity group programs to employees of a certain race, to employees of a certain gender, or any of those other protected characteristics, the EEOC considers that discrimination regardless, even if you are doing it in the interest of trying to highlight some voices that are traditionally not heard. The EEOC also pointed out that business necessity or kind of client or customer preference does not justify taking an employment action based on a protected category. So if your organization's mission is focused on something like advancing, women in a particular program or employment, the EEOC would not consider that to be a justification for only hiring women. So your mission can't be, and your clientele and interests can't be a reason that you discriminate in employment. The last thing that this guidance raised to the forefront is the idea that DEI related trainings may create a hostile work environment. So employers were engaging in a number of different trainings before, like cultural competency or unconscious bias training or inclusive leadership training, which the EEOC has now signaled it's going to be looking at very closely. The executive orders, and including some that we didn't talk about today, really disfavor those types of trainings. They suggest that they make one race kind of guilty for the problems of another, and that it's doing this based on stereotypes. The EEOC is also looking at those sorts of trainings and asking whether they can contribute to their own type of discrimination. Go ahead to the next slide. So knowing that federal agencies like the EEOC and DOJ are looking at these things more closely, and knowing that there are opportunities for new types of litigation, what should you be doing as an employer? The first is looking at your hiring practices. Any of your hiring practices that have areas that are race conscious or gender conscious, or where you're considering or looking at a protected characteristic, you should be questioning why. Why are you looking at race? Why are you looking at gender in the hiring process? And note that this is somewhat different than recruitment. If you're trying to get a broad pool of meritorious candidates, you can absolutely focus on broad recruitment practices. That's different than looking at your applicant pool and putting the thumb on the scale for any person based on their race or gender. So as you're looking at your hiring practices, try to avoid using any race or gender conscious practices in your hiring. If you're trying to get a broader pool of candidates, look at your recruiting practices and see if you can broaden them. For affinity groups have to be open to all employees, not just those in the target group, in order to rise above discrimination-based scrutiny. So you may want to consider publishing guidelines or providing some oversight for your affinity groups to make sure that they're operating properly. They should get equal access and funding regardless of the target group that they're looking at. And if you have any control in approving or disapproving affinity groups that your employees might try to form, you should not be denying groups formation just because it is a group that may not be a traditional affinity group. So if you have a Black employees affinity group and an Asian American employees affinity group, and somebody wants to start a white employees affinity group, affinity groups should be open to employees based on all, for all races, and you should be very hesitant to deny a group's formation. For training, even though there's increased scrutiny in some of these types of trainings like cultural competency and unconscious bias, don't stop your anti-discrimination training. Anti-discrimination training remains an important tool in the employer's tool belt and to both prevent litigation and as a defense to potential discrimination-based litigation. You should be reviewing your training, though, to make sure that it avoids stereotypes and language that could be divisive or that could be problematic under sort of the policy goals that these executive orders have articulated. If you're doing cultural competency or unconscious bias trainings, those in particular should be really carefully done. You can still do them to the extent that you're conveying everyone has biases and leaders should recognize and manage those. But try to cover a broad range of bias. Don't focus on just race-based bias. And avoid stereotypes in your trainings that suggest one race is kind of guilty or should feel guilty for the state of any other. On trainings in particular, note that there are some states that do require trainings that currently may seem in conflict with the executive orders. For example, New York State protects gender identity in its own state-based laws, and it requires specific gender-based harassment and discrimination trainings. That's a good place to talk to your counsel to figure out how to balance those two things. You have to comply with state law, you have to comply with federal law, and when it seems like their intention, you have to tread very carefully in those areas. For complaints, you should be taking all employee objections or complaints seriously. So don't discount a complaint about a DEI program or about reverse discrimination just because they seem like maybe someone's trying to raise issues where there aren't any. Investigate those concerns just like you would with any other types of employment-based complaints. Go ahead to the next slide. Now is a great time to conduct an audit or review of your policies and practices and your training documents to look for these potential problems. Look at your policies, look at your website for any terms or programs that might raise concern and dig into those to see if there are any actual problems on the ground. Just because your policy or your program or your website may have said something like DEI in the past doesn't make it illegal. You really have to look and see whether it actually violates any of the non-discrimination laws that we've talked about. That said, the term DEI is definitely under scrutiny right now. So you can't just go through your website and, delete the phrase DEI and put something else in its place. I don't have a magic phrase to tell you that you can replace DEI with that's going to reduce scrutiny. But you should look at those programs individually. Make sure that there's nothing legally wrong with them from the anti-discrimination law front, and then consider how you may be able to rephrase or reframe them in a way that is more precise and less open to scrutiny. Really take a look at how your program operates, what it's doing and rename it accordingly. You shouldn't just be using DEI as a buzzword to get across this idea of inclusivity. Now is a great time to come up with some more precise names for your programs. With that, I'm going to turn it over to George. For all of you listening in for CLE credit, the CLE word today is inclusive 2025. That's one word, and it's not case sensitive. Inclusive 2025. Thanks.
Thanks, Robin. Very informative. Appreciate it. I did notice maybe one or two quick points, questions that came up that might be worth hitting quickly before switching over to the program side. And I think I know the answer to this, but I'll let you be the one to respond. Obviously, there's a renewed focus from the administration, or an intense focus from the administration on sort of this side of the ledger. Are the courts sort of moving in that direction as well, or have they historically in recent history sort of moved in the direction to say these laws are meant to protect not just the minority, but also the majority group?
Yeah, so the courts have been moving in that direction for a while, actually, even before these executive orders came out. There was a case not too long ago relating to college admissions, where the Supreme Court said that colleges should not be focusing so much on student race in admissions. They should be focusing on experiences instead of an individual's race, so that colleges who were previously kind of putting a thumb on the scale or using race as a plus factor to admit students, we're told that they shouldn't be doing that anymore, that they'll need to look at something more than just the check in the box that says what race an individual is. And that is really indicative of a broader shift in how these laws have really been looked at, is moving away from the idea of increasing representation and really looking at the anti-discrimination laws as, is this a race conscious or gender conscious program or policy? That is been happening. And the executive orders have really just cemented that and moved it quicker from the administrative space.
Right. Good. And then last one real quick is this question about what about training for employees on neurodiversity or emotional mental health and training? That seems unaffected, or am I wrong?
Yeah, so I think it depends on what the training is and what the training is meant to do. So any training that uses a protected characteristic in some way and relies on stereotypes could be problematic under the guidance the EEOC issued. Neurodiversity is potentially a disability, depending on what the issue may be. And emotional and mental health could again be a disability, depending on how severe the mental health problem is. So, it does touch on a protected characteristic to the extent that any sort of training relies on stereotypes, saying something like, autistic people would prefer X over Y. That's potentially problematic under the EEOC's programming. Now, the EEOC doesn't change the fact that you still have obligations as an employer to individuals with disabilities, which includes not discriminating against individuals with disabilities and potentially providing reasonable accommodations. And you can do training on how sort of different perspectives may come to pass as a result of different worldviews, including neurodiversity. But just like any of those cultural competency or, inclusive leadership trainings, you have to be really careful about how you're presenting them to make sure that they're not relying on stereotypes, that they're really doing what you need them to do and are not just sort of broadly trying to tell people to think this way about people with a particular disability.
Got it. Thank you. Very helpful. I will go through now on sort of the other side of the ledger, as I was saying, the notion of nonprofit organizations and their programs and activities, a lot of the outward facing things that you all do or that your clients do when it comes to particularly in this area of DEI, which sort of taking sort of Robin's introductory remarks back up to the forefront here. This is sort of a term that we're all using as shorthand. I know there are different ways to describe these activities, and this may not be as comprehensive a descriptor as others, but that's what we have, and we're kind of using it to sort of convey quickly what we're talking about. I'm talking about things in a non-employment context. So, if you're an organization that may have events where you have affinity groups that meet as among the membership or among the attendees who identify, based on race or some other characteristic. You may offer scholarship programs, either internal to your events and activities or external to educational, to higher education and those sorts of things. Awards, that may honor individuals that may have characteristics or eligibility requirements that are limited to a particular race or background. And then just generally outward advocacy and communications. I mean, these are all the sorts of things that nonprofits do all the time. When we're talking in the non-employment context, there are a lot of sort of different angles that I'm going to cover here. First, we'll start with the grant recipients, and Robin talked a little bit about that, but there are special rules and risks that go along with receiving federal grants. Another point that I'll raise is this issue of maybe race-specific programmatic activities, particularly benefits, grants that the nonprofit may issue, awards that a nonprofit may issue in furtherance of their mission, has been the focus of private litigation even before this administration came along. Talk a little bit about what I had said at the outset. How is it best to sort of create a framework for make these decisions about what to do with your programs as a result of this new risk, and whether it's still worth, in the mind of the nonprofit organization's leadership, to continue pursuing the particular activity, maybe making changes to it. It's all about sort of that balancing of risks and mission. And then, to the extent you've had an ability to analyze that risk and decide how to proceed, then, sort of getting sort of more granular and making sure that your communications and your discussions and how you talk about what you do match what you do and continue to manage that risk. So I'm going to talk a little bit, try not to repeat what Robin said on the executive orders, but they have a sort of a hue to them that are employment related, and also angles to them that are non-employment and more about the programmatic sort of work. And the big one, the one that Robin talked about, I think the third in her list, was 14173, titled Ending Illegal Discrimination and Restoring Merit-Based Opportunity. So among the requirements or the directives in this executive order, when it comes to non-employment context, was a direction to all the agencies to develop a plan to deter DEI programs in the private sector. And it also has provisions, as we talked about, that actually prevents federal contractors and guarantees from considering those sorts of preferences in their employment practices. So we'll talk a little bit about the grant-specific issue in a few slides here. But it also includes this certification requirement that each grant recipient is required to affirmatively certify that they have not operating any programs that promote DEI that violate any applicable federal anti-discrimination laws. And this is where, when this came out, this was a lot of, well, what is DEI? I think the sort of the way the executive order gets around having to define it, it just says illegal DEI or DEI that's contrary to federal law, without ever actually sort of saying exactly what that is. So we are left with a lot of interpretation of courts, decisions over the years and applicable statutes. The issue with the certification is that once it's signed and you're a grant recipient and you sign that certification, it opens the door to potential False Claims Act claims against the individual and the organization that makes the representations. And the executive order also included some encouragement for whistleblowers to come forward. It also provided that the requirements that happened prior to the new administration coming into office, with the affirmative action requirements that are part of grants and contracts, that those don't have to be followed anymore. So there are a number of executive orders from the prior administration that were canceled as a result. Robin talked about the legal status of some of these requirements. It's going to continue. There was a stay, there was a hold on the certification requirement in particular, but the Fourth Circuit allowed it to continue. So many of you who receive federal grants have received some form of a certification language, and I'll talk a little bit about that. There's also 14168, which again, Robin talked a little bit about. It has to do with the gender identity applicable to grant recipients and contractors. It includes some provisions that require contractors to, or I'm sorry, the agencies to no longer include forms that have gender ideology on them. And purports to end federal funding of gender ideology, a term that's not well defined, and then a review of grants and preferences to ensure that funds don't promote this gender ideology concept. So it's really focusing on that. Now, what we've seen in the courts is when it comes to grants that are in process that may have been issued by the prior administration, that may be very much focused on diversity or other of these sorts of things that are purportedly banned by these executive orders, is there have been some success in getting those reinstated in court. As effectively, this is although it's a term to grant, it's a contract between the organization and the federal government. And the grant recipient is doing everything that they can. The government did not terminate according to the rules for terminating grants. So when that's been in place, that's been successful in the courts. But it's a kind of a mixed bag. And obviously, grant recipients know full well that challenging a denial or termination of a grant in court can be quite expensive. So on the grant recipient side, as I said, first off, review the terms of your grant that you have now. If there is one that may be at risk or you may have some concerns about, make sure that you're familiar with those. Some of them have termination provisions, many of them don't. The default termination provision for grants that was in effect at the time of the new administration coming in does not allow termination for convenience if there is no termination for convenience in the grants. So pay close attention, work with your counsel to understand what it really takes to formally and properly terminate it. There is certifications that have gone out. For a period of time, the certifications were kind of worded differently based on the agencies that were sending them out. Now there seems to be some a movement towards uniformity in what those certifications are. It's very brief, the ones that we've seen most frequently. The contractor or prospective offerer certifies that they are in compliance in all respects with all applicable federal anti-discrimination laws that are material to the government's payment decisions for purposes of Section 31, the section of the code, False Claims Act, and that they do not operate any programs promoting diversity, equity, inclusion that violate any applicable federal anti-discrimination laws. So back to that illegal DEI or DEI that violates federal anti-discrimination laws. Again, easy to say in concept, difficult to define in practice. And so by signing that, that's a requirement to continue to receive payments under your grant. You are exposing yourself to a higher level of risk when it comes to potential False Claims Act issues. As I noted, if you do receive, or you're a grant recipient and you do receive a notice of grant termination, a lot of times those notices will come and purport to say there are no appeal rights. And that's not necessarily the case. You may have appeal rights to appeal a termination that took place, particularly if it's not pursuant to the terms of the grant agreement. If there's no termination allowed in the way that it was provided, you may have rights to appeal. Now, it may fall on deaf ears when it comes to being submitted, but it does preserve rights as a grant recipient in the event that there are challenges that are successful down the road. Having submitted that appeal will be an important step. So check with your counsel on that if you do receive that notice. And as many of you know, obviously we're in the midst of budget, reconciliation bills and large pieces of legislation being considered for funding for next year. Pay close attention to what's happening on the appropriation side. Many of you who have significant federal grants are already working closely with your contacts in the particular agencies who, oftentimes you may have good relationships with them. Understand as much as you can what's going to happen on the appropriation side, because there may be some, unfortunately, very significant budget issues that you're going to have to decide. So the earlier, the better when it comes to understanding what the contours of next year is going to look like. And of course, I'm sure many of you are already thinking about this, but private foundations, other sources of support, states might be a way to plug some of those holes that seem to be appearing as a result of the diminished funding from the federal government. I will say, kind of similar to what Robin was bringing up regarding the differences between state laws on employment and processes on the employment side. There may be state grants that have provisions that require or mandate you as an organization to do things that might be contrary to what the federal government is saying you can do under their new rules with regard to grants from the feds. So obviously, when you have that tension, when you have that conflict between the two, work closely with your counsel to see how to best navigate that tricky situation. Okay, let's go to some of the sort of non-grant recipient programmatic issues. That executive order that I talked about briefly, more from the grant perspective, also includes a dictate to agency heads that they are to take that 120 days that Robin talked about, look at organizations, companies, and other sectors, and basically report back through to the AG what sort of deficiencies or problems they've identified there. Specifically, among the items that they were supposed to report back by May 21st were instances of the most egregious and discriminatory DEI practitioners in each area of concern. They're supposed to identify key sectors of concern and then go beyond the sectors and then identify those most egregious and discriminatory DEI practitioners, and specifically identifying large nonprofit corporations and associations, private foundations with assets over $500 million. In addition, publicly traded corporations, state and local bar and medical associations, and higher education entities with assets over $1 billion were expressly mentioned that each of these agency heads are supposed to go out and sort of find these examples and instances of egregious DEI. We've not heard anything as to, May 21 came and went, but there still could be some I'm sure there will be some follow-up on this, so we will keep an eye on that. But that's part of what the environment is showing us right now. So I mentioned, that's sort of the administration's position. It sort of mirrors what was, brought up very well by Robin earlier. There are also a lot of private plaintiffs that are moving in this area when it comes to nonprofit programming. And it actually began before this administration came about, and there are a number of cases that are out there. Probably the most visible is the one called Fearless Fund, which I'll talk a little bit about. Most of them use that Section 1981 of the Civil Rights Act as the basis for their claim that an organization's activities were discriminatory against white participants. The groups are, it's usually sort of non-federally funded programs as well. There was a lawsuit against American Association of University Women regarding a scholarship program that had a limitation based on race. That was a settlement by AAUW soon after it was filed. There was a lawsuit filed against an organization called Founders First Community Development Corporation, and the plaintiffs were able to get a preliminary injunction there. And that program was offered benefits, scholarships, grants limited to people in these categories here on my slide here, but includes notably not just limitation by race, but also gender, LGBTQIA plus, military veterans, and someone who lives in a low to moderate income area. So it was a broad set of people who could benefit from the scholarship program or the grant program that this organization had initiated. But nonetheless, there was a lawsuit filed, and I'll get to why that's important in a bit. But when that was filed, soon thereafter, there was a injunction issued by the U.S. District Court, Northern District of Texas, and there's since been a settlement, and that program's no longer in operation. And also another one that's not on this slide, there was a lawsuit filed against a major association that has a significant minority-based scholarship program for individuals in higher education, individuals sort of pursuing a degree, and that lawsuit was filed not too long ago as well. So sort of the punchline, not to sort of bury the lead, there's been a lot of decisions on a very preliminary basis on this theory that under Section 1981 of the Civil Rights Act, these activities were contrary to law. But it's really a preliminary injunction and a preliminary injunction in two. So the District Court in Northern District of Texas and the 11th Circuit Court of Appeals, which I'll talk about regarding the Fearless Fund in a second here. There's not been a sort of substantive ruling yet on whether, or at least on this particular wave of cases, whether these sorts of things are truly violating of Section 1981. And there are some arguments and some great scholarship out there after Fearless Fund came about that's worth reviewing as to whether there are decent arguments to beat that back. Of course, that's an expensive endeavor. That's a timely endeavor. That's a time-consuming endeavor, and maybe it's something for a test case somewhere along the lines. But just want to emphasize that this is where the courts seem to be heading, but there's not a final decision on the substantive point. So Fearless Foundation is part of the Fearless Fund litigation. This was an entity that offered a scholarship program for women-owned Black businesses. And it was a grant that would help support those businesses. There was a plaintiff organization, American Alliance for Equal Rights, sued, claimed violation of 1981. This law was something that was enacted way back in 1866, and it's supposed to remedy discrimination against Black people in the wake of the Civil War, granting all persons the same right to make and enforce contracts as is enjoyed by white citizens. So the applicants were required to agree to be bound by. In this case, Fearless Foundation had this grant. The applicants were required to be bound by the rules of the grant program, and that was determined by the court to be considered a contract. So you sort of have that one element, the contract is there, and then the court, which the initial attempt for the plaintiffs to be successful on the preliminary injunction was unsuccessful at district court in Georgia, but got appealed up to the 11th Circuit, which said, no, this should be enjoined. The court also noted that there's unlikely to be the benefit of what's called the remedial, the remedial exception to that would allow for affirmative action in some cases, usually in the employment context. To apply that to the non-employment context, it refused to do that. So basically, the court favored the argument of the plaintiffs. I mean, we could talk a lot about standing. That was a big part of it, but sort of not as important today. A lot of the takeaways here are, like I say, the trend points to a more restrictive environment for programs that are benefiting only or predominantly or somehow restricting access based on race. There are good arguments to say that there's reasons 1981 doesn't apply. There are also other ways besides Section 1981 that a court or a plaintiff could try to say that a program that is exclusively benefiting people of a certain race is illegal or restrictive. So there's sort of charitable trust doctrine theories. There's also Section 1982 of the Civil Rights Act, which prohibits or requires everyone to have the same right as enjoyed by white citizens to inherit, purchase, lease, sell, hold, and convey real or personal property. So there are these sort of angles that the plaintiff groups are taking. I think when we look at the benefits, not all the programs are going to be the same. I talked at the outset what some nonprofits offer. I think scholarships and grants are going to be the most closely focused because there's some tangible benefit that goes along with that that would be denied if the restrictions in place prohibit white people, for instance, from qualifying. Awards, I think, are less concerning. Affinity groups, even less so. Let's talk a little bit more in detail quickly. I'm going to run over. Obviously, it's 1:31 now, so I expect to just be another 4 or 5 minutes. So I think when it comes, we've talked with a lot of organizations that have offered some sort of scholarship programs, either internal to their organization or for education or some other purpose, where the beneficiaries are limited by race. I think this is sort of the highest risk. The plaintiffs are going after this and have had, as I say, some preliminary success. Many of our clients will come to us and say, okay, can we just add a tack on to say, or anyone else from an underrepresented community, or add some non-race-based eligibility requirements. I would say that one case in Texas that I talked about is an example of one where there were some non-race-based qualifications or eligibilities, but that was also one that was enjoined and was then settled. So I think, in terms of the risk calculus, having a grant or scholarship program where there's some tangible benefits available to your members or others, having that sort of be non-race defined, and maybe there are other characteristics that aren't based on race that you can use, such as, I think historically underrepresented sort of gets to it, be a surrogate or proxy, but something more sort of along the lines of perhaps, overcoming obstacles or overcoming challenges, something that meets your organization's mission and doesn't necessarily restrict the beneficiaries only to race, would be a less risky position to be in than one that just tacks on some non-race related characteristics. A lot of what we've talked about with some of our clients before is, can we get out of Section 1981 liability by pointing out that it's not really a contract, that we're doing this grant solely, I think, based on some expectation that you'll take that award and do good with it, but we're not going to sort of ask you to release us or allow us to use your name and likeness or anything like that would have the contract aspect. That's, I think, possible, but a very difficult, road to go, because the courts have thus far shown a willingness to find a contract, even though there might not be some formality to an agreement or something that actually has the title contract on it. If there are some requirements that are being imposed on the grant recipient, they will find a contract. So I wouldn't put all of our eggs in that basket, although that's a way to minimize or at least try to lessen some of the risk. I think awards, generally, unless there's some sort of financial benefit to it, it just seems to be in a less sort of risky category. You still could have someone claim that they are being denied some benefit or right that they might otherwise have because this award is only eligible or made available to, individuals of certain minority background. But if the benefits are little to none, maybe the ability to speak or accept the award at an event or something like that, it seems just a less risky environment when it comes to it being a likely target for plaintiffs that are concerned about this. Still, there could be some claims that Section 1981 applies, but I feel like the contract argument's a much more difficult one. Again, you can still manage those risks by looking at eligibility and maybe turn the award from one that's only the people eligible are from a particular racial background, but to make it honoring people who champion people from particular backgrounds, or that champion or defeating inequality, for instance, where you turn around that eligibility a little bit, so it's not based on the characteristic of the person, but rather the work that they did. I think the risk goes down a lot with that sort of approach. I think having affinity groups at an association or other nonprofit events. The Widget Manufacturers Association may have sort of the Black Widget Manufacturers Affinity Group or something like that. Again, this is different from the employment context. I think still, you may consider to totally manage your risk and lessen it, to open it up to anyone who wants to attend, even though the affinity group may be focused on someone from a particular background. I think that the risk there is less than it is in the employment context, because all those laws that Robin went through that apply in the employment context do not here, and you're not very unlikely to have a contract argument here as well. And certainly the least risk, I think, is continuing your advocacy work and your mission-related work, where you're speaking about how important it is for your organization's mission to do this or that, whatever it might be. You know, the public statements, any sort of advocacy work is clearly protected First Amendment speech, and even some of the courts that have been pretty restrictive on some of their decisions when it comes to activities of employers or others always sort of make clear in their decisions that this is not to silence any advocacy or other sort of statement that's not tied to a contract or not tied to employment. Okay, I've got a few others that'll be on the slides that I'm not going to talk about here, but some people have been concerned about Section 501c3 status, and could the IRS, under this administration, decide that this illegal DEI activity means you're an organization engaged in illegal activity, and therefore this illegality doctrine could apply, and you would be at risk of losing your exempt status. That would be sort of a twist on the Bob Jones University decision that many of those of you who practice with 501c3 know quite well, that sort of really solidified the illegality doctrine. I think there's not been an indication yet that there's been a total shift in enforcement from the IRS, that they're focusing on this and audits, or in fact, very recently, some private foundations have had scholarship programs approved by the IRS that actually were limited based on race. So there's maybe a disconnect internally with the IRS right now. We're going to keep monitoring that to see if there's anything that may be happening when it comes to either Internal Revenue Code changes. Nothing that we've seen in the current legislation that's coming out has that. Whether regulatory, which would require notice and comment, or most likely would they seek to either retire, revise, or update certain revenue rulings or revenue procedures where you don't have to go through notice and comment, and try to then sort of change what sort of is acceptable when it comes to 501c3 and diversity-related activities. One of the obvious ones is the revenue ruling that was a subject of the Bob Jones University decision, having to do with anti-discrimination policies of private educational institutions. We've yet to see that, but that's something we'll keep an eye on. So things to consider. I know I'm going over what I estimate I go over, but this is my last one. What is the risk that you're willing to tolerate as an organization? How key is some of these activities to your mission, and how important it is for you to continue that? Balance that against the risks that we've talked about when it comes to potentially being a target of private litigation, or maybe one of these agencies that's looking for these examples of egregious DEI, settle on you. You have to balance those risks, of being brought into a litigation or having sort of scrutiny from the federal government against the commitment you have to your mission and how close this is to your mission. And then, if you're a grant recipient or a contractor, obviously there are unique and important other risks to consider there. And then look at your program specifically. Look at them, what you say about them, how they operate. Can there be tweaks and changes that won't really change the core focus of those programs, but put you in that lower risk category? So not hitting sort of your mission too hard, or sort of turning away from your mission, but doing it in a way that's careful and thoughtful, so that you can be less likely to find yourself as a defendant in one of these litigations, or find yourself as a focus of one of these agency actions. Check all the public-facing documents, your website, et cetera, just as Robin was suggesting before. And we'll do our best to keep all of you informed, but try to stay abreast. Things are changing quickly, and I think it's important to be as up to speed as you can. Whew, with that, I'll say thank you for indulging me those extra 10 minutes, and I hope you were able to learn a few things today. We do have some questions, and we'll see if we can get back to them after the event, after we close this out. One last time, the CLE code is inclusive 2025. Inclusive 2025. With that, I will say thank you, Robin, for your thoughtful presentation, and thank you all for participating. And we will be back with you next month.